Hi there. In India, any two people, irrespective of their sex, gender, or sexual orientation, have the right to choose their partners, cohabit or live together, and generally have the state or the government not interfering in their personal business. There was some statutory law that prevented sexual intimacy between two partners of the same sex. That is, Section 377 of the Indian Penal Code. But the Supreme Court stepped in and struck down that provision as being unconstitutional. But choosing one's partner or living with that partner is not quite the same as marrying a partner. The moment the question of marriage comes up, immediately the law and the government get very interested in what's going on. As one judge from the USA put it, every civil marriage has three parties, two consenting partners, and an approving state. Where and what then is the line between a marriage and a live-in relationship? Legal recognition. Marriage brings with it various legal rights. For example, there are rights under the income tax laws, under employee benefit laws such as the laws governing pension. There are also implications under the adoption laws and as to the succession rights of children of the couple. Marriage also brings obligations with it. The state would like to ensure that marriages survive in the interests of the children and presumably also in the interests of the couple. Therefore, in India, in most communities, a divorce can only be obtained by an order of the court. Therefore, it is not very easy to get out of a marriage. All these rights and obligations are conferred on the basis of marital status by the law. Therefore, marriage is as much legal as it is social. Considering that so much of what defines marriage is its legal consequences, marriage is a status that must be conferred by law. But, and I hope you've watched the last video, custom can also be law. Therefore, if marriage is recognized by custom and no statutory law comes in the way of it, customary marriages will also be recognized by the law. In India, most of the marriage law, especially for Hindus and Muslims, is customary. While the Hindu Marriage Act has somewhat modified some of the law relating to Hindu marriages, it has not thrown out the customary law of marriages in full. Therefore, who makes the law on marriage? Both custom and the legislature. A person is said to be heterosexual when they are attracted to people of the opposite sex. Heterosexual marriages have been around for a long time. There is custom in India which recognizes heterosexual marriage. There is also statutory law which recognizes it. A person is said to be homosexual when they are attracted to people of the same sex. Apparently, however, there is no recognition of homosexual or non-heterosexual marriages in customary law in India. There is also no statutory law which recognizes this kind of marriage. Can the courts then step in to create the legal framework to recognize non-heterosexual matrimony? The Supreme Court of India has answered precisely that question. Two heterosexual Hindus of the same caste or community marrying each other is recognized by custom. The same is true for Jews or Parsis or Christians or Muslims. However, since customs are different for different communities, there was some vacant space in the law on the question of whether two people belonging to different communities, even if they were heterosexual, could marry each other. Custom either did not deal with this at all or was somewhat unclear on this question. Therefore, there was some doubt on whether customary law recognized such marriages. Similarly, there were also doubts as to whether people who did not belong to any religious faith at all could get married and whether their marriages would be recognized by law. Therefore, in 1872, a Special Marriage Act 1872 was enacted. This act provided for the recognition of marriages between two persons, neither of whom practiced various religions, including Hinduism, Buddhism, Sikhism, Jainism, Christianity, Islam, etc. The difficulty with this law, however, was that if either party to the marriage practiced any one of these religions, the act would not apply and presumably the marriage would not be recognized by law. Therefore, the Special Marriage Act 1872 required that both parties to the marriage surrender or renounce their religion to permit their marriage to be recognized under that law. Recognizing this difficulty, in 1954, another Special Marriage Act was enacted. This time, the Act provided that any two persons could get married. This ensured that these two persons could either be irreligious or not belong to any particular community or caste, or belong to different castes, communities, or religions, but still have their marriages recognized by law. This Act also had the effect of overriding any custom that prevented these kinds of marriages. In Supriyo versus Union of India, the Supreme Court of India considered various questions, but we'll look at two of them. First, it considered whether people belonging to the LGBTQ or queer community, that is, non-heterosexual people, have a right to marry. And second, it considered whether the Special Marriage Act of 1954, by not providing for non-heterosexual marriages, was discriminatory and unconstitutional. The Supriyo case was heard by a bench of 5 judges who wrote 4 judgments, ending up with a majority of 3 judges and a minority of 2 judges to reach one conclusion. Thank you.